KU Law Professor Richard Levy talking about West Virginia versus EPA on this week's Renew Guru. Hello out there in podcast world. This is Renew Gurus, your source for all things energy policy and politics in Missouri and beyond. I'm Executive Director of Renew Missouri, James Owen, coming to you live on tape from our palatial studios in North Columbia. I am also our producer today because Philip has got a conflict, but as a special co-host, I have our St. Louis director / counsel, Andrew Linares. Hey, Andrew, how are you?
Hey, James, great to be here, zooming in from St. Louis.
Yeah, oh my gosh. I feel like this is like whenever Frank Sinatra would come on the Tonight Show with Johnny Carson. Like he just kind of comes in as like the marquee guest, and we don't have you on enough, Andrew.
It's true, yeah.
But we do have a special.
Great to be here.
Yeah, it's great to have you. We do have kind of a topic that you're interested in, and it is really not involving renewables or efficiency or anything like that, but it is kind of involving a topic that has been of interest to clean energy advocates and environmental advocates around the country. It is the decision that was brought down by the Supreme Court a couple of weeks ago in the West Virginia versus EPA case. There's been a lot of questions about what that means, about what that will do moving forward. And so to kind of talk about that, I have brought on someone who has meant a lot to me in my career as a lawyer, my old con law professor, my old legislation professor, the director of my public policy clinic from KU Law. He also supervised me doing a paper on the Help America to Vote Act back in 2003, and gave me a very good grade for that. So I'm always appreciative to Professor Richard Levy. Professor Levy, how are you today?
Oh, I'm doing all right. Like everyone, I've been watching recent Supreme Court decisions with great interest, including the West Virginia versus EPA decision. And so I'm happy to be on, and thank you for the invitation to talk about this decision, which I think has really important implications, not only for climate change, energy policy, but also more generally for the role of administrative agencies in U.S. government.
Right. Yeah. So before we dive in that, can you kind of say a little bit about give us the like 5-cent tour of your background, what you teach, where you've got your education, just a little bit about you.
Sure. Well, I am a native Kansan, at least as close as you can be, having lived in Topeka since the time I was 2 weeks old, with a brief stint out while my dad was in the Air Force.
Okay.
I'm a KU undergrad. I also have a master's degree in, of all things, German literature, which is a story for another day. But like many people with that sort of degree, my fallback plan was to go to law school. So I went to law school at the University of Chicago Law School. And after I graduated from the University of Chicago, I clerked for a federal court of appeals judge there, Judge Richard Posner.
We've heard of him, haven't we, Andrew?
Yeah, he's pretty famous. Right. He's a pretty famous judge, and that clerkship opened a lot of doors for me, including a door to be a member of the faculty at the KU Law School, where I joined the faculty in 1985. I've been here ever since.
Wow.
My focus in teaching and research would be broadly defined to include what we might call public law. That is the law involving how government intersects or regulates the general population, the private sector, people. And that includes constitutional law, administrative law, statutes and legislation, and general public policy kinds of matters. And I've taught and written in all of those areas. Maybe my biggest claim to fame and the qualification that would be most relevant to this podcast is that I'm co-author of an administrative law textbook that's published by Foundation Press, which is now in its third edition, and that my co-author and I will likely have to completely rewrite as a result of recent Supreme Court decisions.
You are way too qualified to be on this podcast. But yeah, I mean, which all of that is why I wanted to have you on here, because when this case that you've referenced, West Virginia versus EPA came down, there was a lot of questions about what that meant. And I guess thinking about this from like approaching it from a law school perspective, can we talk a little bit about what generally that case was about? What was the Supreme Court there being asked to decide?
Okay, well, at bottom, it was a legal challenge to the so-called Clean Air Plan that had been adopted by EPA under the Obama administration. That plan had never gone into effect, but the authority to adopt the plan was challenged. So the fundamental basis of the legal challenge was EPA had no authority to adopt the regulations that it did under the statutory provisions that EPA relied on. And ultimately, the critical issue is it's clear that EPA has at least some authority to regulate greenhouse gas emissions. That had been established long ago. But the question was whether the particular provision that they relied on relating to power plants granted authority to EPA to require power plants to shift their method of generating electricity away from coal towards cleaner fossil fuels and away from fossil fuels towards renewable or non-carbon generating kinds of sources. And ultimately, the court held that they did not have that authority. So they can require plants to be cleaner, but they can't require them to shift their method of generation in order to be cleaner.
And this is an issue that has never been in front of the court in this way, but it's something that the Clean Air Act and Section 111 and all this stuff has been an issue in front of the court for the past couple decades. The Clean Air Act obviously is passed back in the Nixon era. And then there was the 1990 amendments and whatnot. And actually, there was a decision in 2007 that James and I were talking about, is I guess kind of part of my humble origin story. I was an English student, literature student, much like yourself. And in 2007, I was living in Europe, studying abroad and studying German literature, actually.
Really?
Funny enough.
Sehr gut.
I didn't know that.
not in the German, of course, but I was living. I was studying abroad, and the Massachusetts decision came down in 2007, and it was really one of the big reasons why I decided to go to law school and study environmental law. And I read Justice Stevens' opinion before I knew what a Supreme Court opinion was, and I really kind of got my inspiration to go to law school because of that. And that all came from a decision under the Clean Air Act about whether a finding, it hinged on whether carbon dioxide could be considered a pollutant under the act. And I'm wondering if you could just talk us through that and how this new decision, the West Virginia decision, shows the shift in the way the court is approaching the regulation of carbon by the executive branch.
Well, I don't know that you could say that there's a direct shift. So the issue in Massachusetts versus EPA concerned what substances qualify for regulation because they pollute the ambient air. And Massachusetts versus EPA considered whether carbon dioxide was a chemical substance that qualified as a pollutant because it would have harmful effects on on public health. And the language of the statute, both its definition of what constituted a pollutant and its definition of what constituted a harm or threat to public health, were sufficiently clear that carbon dioxide qualified. And the court rejected the argument that, well, it's not a pollutant because carbon dioxide exists naturally in the air. That didn't take it outside of the scope of what would be a pollutant. So once you determine that it's a pollutant, then EPA was obligated to make a finding about whether or not it was harmful to public health. And if it was harmful to public health, then EPA was obligated to regulate it. And the court didn't answer those questions, send it back down to the lower courts for resolution of those questions. But ultimately, that case stands for the proposition that EPA has authority to regulate greenhouse gas emissions.
Right.
Now,
right.
there's nothing in West Virginia versus EPA that overturns or alters that conclusion. Instead, the West Virginia case is focused on what authority EPA has to regulate those emissions. And so it still has the authority. The question is, does that authority include the authority to require power plants to shift their mechanism of generating electricity?
Right.
And it wouldn't matter what the pollutant is. The answer in West Virginia versus EPA would be the same. So you couldn't require generation shifting to reduce sulfur dioxide or other kinds of pollutants. You would still be required to essentially work on the technology for the particular plant's generation system or mechanism to make it cleaner. You couldn't require them to change over to a different source altogether.
Right. That's okay. So that's a useful distinction. So, back in 2007, we had this finding that the EPA could indeed regulate carbon as a pollutant. And for those advocates out there, fast forward a couple of years, 2014, everyone was talking about 111D, Section 111D, and that became the Clean Power Plan in 2015, which was the subject of a lot of advocacy and rulemaking. And then, of course, we had the election in 2016, and it took a couple of years, but they halted the Clean Power Plan in its tracks in the whole scheme that EPA had put together to require states to take action on stationary source on power plants, essentially. And that Clean Power Plan process was never concluded, never went into effect. But the Supreme Court still had the authority and the prerogative here to continue to discuss that question. Can you talk about that? Like, why was this even at issue if the Clean Power Plan never went into effect?
Well, that's a good question. There is a doctrine related to the jurisdiction of federal courts known as the mootness doctrine. So normally, when a legal issue is no longer live, particularly because the government has withdrawn or changed the law in ways that make the issue go away, a court will usually dismiss that as moot. Nonetheless, there's an exception for mootness from mootness doctrine when an issue is, they say, capable of repetition and a matter of great public interest. So they may go ahead and take it. So the court essentially was in a position to decide, we need to resolve the question of EPA's authority because this issue is likely to come up again. EPA is likely to rely on 111D again for a similar kind of plan. So we're going to resolve that question now. That's pretty much within the court's discretion, like a lot of decisions that the court makes. The majority of justices wanted to resolve the issue, so they did.
Right. And so now we're, hopefully our listeners are hanging in there with us through this all this legal jargon. But what does this mean now in a larger sense? I mean, this case comes down in the midst of a raft of Supreme Court decisions that are really changing the way the court and the federal government approaches big issues. Obviously the abortion decision and the regulation of carbon dioxide here. So what do you think this signals in terms of like the larger approach of the court and the federal Congress, and where does this fit into all of that?
That's a big question that we probably need to break down into a lot of different areas. So I'm going to focus on an aspect of constitutional law that's known as the separation of powers, and approach it from that direction. I'll leave issues of fundamental constitutional rights, like the right to abortion, for another day, but I will say that there's a connection in the sense that all of them are, all of the court's decisions align with a very conservative political agenda, which is not surprising considering the efforts to appoint conservative justices in recent years. So once we have a clear, really a supermajority, 6 very conservative justices, even if one of those justices may choose not to go along, there's a majority of conservatives that are willing to pursue what appears to be a very conservative agenda. Contrary to what I said, we can look at things like religious freedom and free exercise cases that have minimized the role of the Establishment Clause and promoted the freedom of particularly Christians to exercise their religion and enact their religion as a matter of public policy. We have abortion rights decisions, but we also have gun rights decisions would be another one. But we also have one more case in a series of decisions that have reinvigorated separation of powers doctrines in ways that sharply constrain the ability of administrative agencies to act in the public interest. And that really all goes back about 80 to 90 years to the New Deal period. I don't know whether your viewers and listeners are interested in a history lesson, but until about 1937, from about 1890 to 1937, the Supreme Court was very anti-regulation. They struck down many laws that were designed to create rights for workers, to protect the worker health and safety or the general public. They relied on various doctrines to do so. Sometimes they relied on what was called substantive due process to protect freedom of contract and strike down things like minimum wage laws because they violated freedom of contract. Sometimes they relied on federalism and struck down federal programs because they interfered with reserved state police powers, like the application of antitrust laws to manufacturing of sugar or steel. And sometimes they relied on separation of powers to hold that administrative agencies had been given too much authority in that authority was incompatible with the vesting of legislative power in Congress. And the idea was that only Congress could make important public policy decisions. In about 1937, at the height of the Great Depression and after Franklin Roosevelt won landslide re-election, partly campaigning against the court, one justice changed his vote from anti-regulation to pro-regulation. That justice, coincidentally, was named Roberts. The change in vote pretty much undercut what President Roosevelt's court packing plan, which was designed to expand the court so that he could appoint up to 6 new justices and change its direction. If that sounds vaguely familiar, there's a kind of echo of history going on here to a certain extent. In any case, I mentioned that because the switch or the change in votes by Justice Roberts is sometimes referred to as the switch in time that saved 9, as a play on the traditional proverb. In any case, after that, the court relaxed all of its restrictions on government regulation and generally endorsed the idea that Congress and the agencies had broad authority to protect the public, to regulate business, industry, private property in ways that were designed to further the public interest, pursuant to broad general delegations of authority. The West Virginia case represents a sharp departure from that kind of perspective. And the way that it does that is through the adoption of what's known as the Major Questions Doctrine, which was something that was actually never called that in a Supreme Court case until West Virginia, but had been coined in some ways by then Judge Kavanaugh when he was on the District of Columbia Court of Appeals. And there are echoes of it in some other recent decisions, but it emerged full bore as a significant limit on agency power in West Virginia. Under the Major Questions Doctrine, as adopted in West Virginia, when an agency claims power to make a major policy decision, it has to point to basically explicit statutory authority to do that. Broad general language in the statute is not enough. And the court explained that major questions of policy should be adopted by Congress, and the sort of assertion of that sort of authority by agencies was contrary to the separation of powers and the scheme of government in which Congress, the lawmaker, is representative in character. So under the Major Questions Doctrine, the court will essentially read statutes narrowly to prevent agencies from resolving major policy questions. The court didn't give us a lot of clues as to what makes a question a major question. There was a concurring opinion where Justice Gorsuch said, well, anything an agency does that has significant policy or political, political, economic, or federalism implications would make it a major question, which seems to be almost anything that an agency might want to do. So the Major Questions Doctrine would appear to operate as an all-purpose mechanism to restrict agency power.
That's fascinating because, you know, I wasn't looking at this case in terms of that level of historical significance, but you know, this implicates the the amount of deference that the court has historically brought to agency decisions.
It's also, although it purports to be deferential to Congress, it's actually not deferential to Congress. It reduces deference to Congress because it basically says, Congress, you can't give broad authority. You've got to go through and give specific authority for everything you want agencies to be able to do, which makes it much more difficult for Congress to act.
Yeah, because I was thinking, like, as you were talking, like, what if like that presupposes that Congress doesn't want to be broad with what they give to
right. And what the court is essentially saying is Congress can't be broad. If Congress is broad, that violates separation of powers. Congress has to do it itself. It can't delegate that to an agency. And even so, the language of the statute 111D easily covers and encompasses what the agency did, because it authorizes the agency to, prescribe systems for reduction of emissions. And generation shifting is a system for reducing emissions. So it fits within the statutory language easily, but the court said that's not enough. It's got to be specifically authorized. If it's that important, Congress has to say, yes, you can shift production of electricity from one method to another. And because it didn't explicitly do that, Congress didn't explicitly say that, the agency can't do it.
And this all comes at a time when the legislature, the Congress has seen sort of historic deadlock. I mean, really, since the New Deal, you could say that we've seen a decline in the effectiveness of the Congress, I think it's
the
probably cloture rule.
It's probably more since the 80s and 90s. So there, the filibuster has changed over time. It used to be you actually had to hold the floor. Now you don't.
Right.
It used to be that you would actually force a vote on all of these things, but now you just say, "Oh, I'm going to filibuster," and everybody goes home and packs their bags. So the filibuster, it's a signal of dysfunction or a cause of some dysfunction, and absolutely, I don't think it's a coincidence that the court has required Congress to be explicit at a time when Congress could not possibly be explicit. Or correct a misinterpretation of the court. It's probably not a coincidence that the court is hamstringing agencies when they are the only functional part of the federal government in terms of responding to crises or problems. Just to sort of put it into context, you probably heard that the court invalidated OSHA regulations requiring large employers to require vaccination of employees.
Right.
That relied on the Major Question Doctrine or its equivalent as well, because the language of the statute would have easily encompassed that, but the court said, well, we don't think Congress meant to allow regulation that goes beyond in the workplace in this way. It's a major question. Now, that was one that was, also very limiting on OSHA's authority. They also narrowly construed the Center for Disease Control's authority in striking down a moratorium on evictions for similar sorts of reasons. So this is a broader kind of opposition. Another area where they've been active, less directly relevant to this podcast, is casting down on so-called independent agencies and sort of indicating that protections in civil service and other laws that limit firing of executive officials to good cause are constitutionally suspect because they interfere with the president's authority over the executive branch.
Yeah, there's this tension here. I mean, to bring it back around to the Clean Air Act and what we can do to respond to, perhaps the biggest global challenge out there, there's this tension between, the Major Questions Doctrine or doing this, requiring this tight textual reading of statutes and doing what's practically needed to manage a global challenge, which, as you said, our executive agencies are probably the only functional part of the federal government that are capable of regulating the largest economy on earth and regulating the fuels that are backing the global economy. I mean, it's a huge challenge, and
Absolutely.
at a time when Congress doesn't seem to have its act together, how else do we tackle this if not in big federal agencies?
Yeah, sort of going to the broad scheme of things, I think one theme that that unites many of the court's most controversial decisions from this last term is the justices seem completely unconcerned with the actual consequences in the real world of their decisions. They're not concerned about gun violence. They're only concerned about the historical meaning of the Second Amendment. They're not concerned about the practical impact of allowing Christians to basically express their religion from positions of power in the public sphere, and they're not concerned with the real consequences of abortion regulations for women, and they're clearly not concerned about global climate change either. So none of these consequences had any impact. They're focused on a kind of what one scholar has referred to as airy formalism, right? So they're focused on articulating principles that they're going to follow, regardless of where those principles lead in the real world.
Right. Yeah, because that kind of brings me back, because you're talking about the major questions issue. Because I mean, a lot of these Supreme Court justices who signed on to this decision, the West Virginia versus EPA, are very much about the original intent of the founders and the original intent of the people who wrote these amendments. I mean, how does that reconcile? I mean, is there a rationale for that in this decision about how a major questions goes to Article 2? No,
it goes.
1,
it's Article 1. Yeah. Right. So there's very definitely an originalist cast to the decision based on a kind of assumption that under the original separation of powers principles as understood in 1789, there would be a sharp differentiation between legislative power, executive power, and judicial power, where overlapping powers would not be acceptable. And the assumption is that at the time of the founding, Congress would not delegate these kinds of powers to administrative officials, and that's the line that they're sort of drawing. The problem is, first of all, there's a lot of evidence that that's historically inaccurate. That is, early statutes did, in fact, delegate lots of authority under open-ended standards to executive branch officials. So, and part of the problem with originalism is that it purports to be neutral and provide a sort of clear external sources for what the court does, when anybody who studied history knows that it's contested and always contested, and there's no clarity to history. And in fact, relying on history opens the door to a kind of cherry picking process where you find the historical sources that support your position to be persuasive, and you minimize or ignore the historical information that's incompatible with what you've done. And that's been true in a lot of the originalist decisions, or nominally originalist decisions. Dobbs cherry-picked history, the Second Amendment case cherry-picked history, and the religious freedom cases also tend to cherry pick history. So I've always felt like originalism claims to be neutral, but it's really not. And that history is a lot like a Rorschach test, in which you see in history that which you brought to the table rather than objectively assessing it. It's also, I'll be right up front. I think originalism is deeply flawed. Another flaw I find in originalism is that in 1789, or even the 1860s, when the Civil War amendments were adopted, the franchise was very limited. Only propertied white men participated in drafting and approving the original Constitution. Women, slaves, Native Americans had no say. So one of the claims of originalism is that, well, we gain legitimacy because we're relying on the text of the Constitution as originally adopted. But it's hard to see how that original adoption confers a lot of legitimacy when so many swaths of our population were not represented. More broadly, nobody alive today participated in the approval of the Constitution. So to the extent it's legitimate, it's because we now recognize it as legitimate as members of modern society.
Right.
And in that respect, we recognize it as legitimate, not because of what it said and meant in 1789, but because of what it says and means today. So I don't see originalism as supporting any kind of legitimacy on the part of the court's decisions. In fact, it renders them, in my view, less legitimate because it ignores all of the sort of precedents and developments since 1789 that have made the Constitution more just.
Right. And yeah, I mean, that's a really profound insight about the structure of our government and our court system and everything. And I'm wondering at the end here, as we wrap up, I'm wondering if there's a way for us to see some light amidst this doom and gloom. And, we're at the state level, we're state advocates. Many people who listen to this are at that level. And we, to some extent, the Clean Power Plan, we all know, was by no means a cure-all for climate change. I mean, I remember looking at a lot of the analysis for the Clean Power Plan, and many states were already on the path to compliance, and the reductions were to some extent already baked in just because of the way the American economy was going. And you could say that to really tackle climate change, we were always going to need congressional action and international action and a larger movement that went beyond what EPA was proposing. So I'm just wondering, how would you say this decision affects the state of play for state advocates and their work, and what is the next thing for them to focus on going forward?
Well, the old saying, you have to be careful what you wish for. I came of age in the 70s when liberal/progressive politics dominated the conversation, and abortion rights were being recognized and applied strongly, when government regulation was accepted as a good thing broadly by large swaths of the population. Even as that was happening, the beginnings of backlash against it were underway. And, it wasn't that long after that we had Reagan and the emergence of a strong conservative movement that has built momentum over time and essentially routed the forces of liberalism and progressivism, changing the conversation at a pretty fundamental level. And I believe that we may be approaching a similar kind of moment where conservatism has achieved so many of its goals, and in the process laid bare what that really looks like. And in so doing, they may have generated or laid the foundations for a strong backlash going the other way. So, if you're looking for a ray of optimism, I would say these kinds of actions may focus attention and generate the kind of grassroots activism that would be necessary to change political momentum and change the political conversation over time. Now, I don't think it'll happen right away. It's a long-term kind of process, but the last time the Supreme Court was this way, it eventually gave us Roosevelt and a liberal court by way of backlash and political response. So it's entirely possible that even as the Republican Party, and particularly the most conservative elements of the Republican Party, see victory on multiple fronts, that could produce the kind of political response long term that would lead to more fundamental change.
Mm-hmm. Well, yeah, I mean, I certainly know that some people, when they get success, they tend to become apathetic too. And so in addition to like kind of mobilizing people who have seen, who don't like what they've seen, who have disagreed with this, and this mobilizes them. Sometimes when you've reached, there are people who've been working on this issue for 40, 50 years. And they've reached it.
Right. Yeah. So I definitely feel like all you have to do, again, I hate to come back to Dobbs and Roe, but Roe and Casey gave a false sense of security to supporters of choice, that they didn't have to worry about the political dimension of abortion rights because they had a constitutional safeguard. And so they didn't vote on abortion as a single issue anymore. They were focused on a variety of different issues and not really energized around that sort of questions. Conversely, Roe galvanized a strong movement against abortion rights and related sort of religious, the religious right generally, and social issues surrounding that. That was galvanized, and we may start to see the reverse be true as anti-abortion forces and people on the right have succeeded. Then they may become more complacent and opponents may become more active. The same could be true of regulation and the forces against regulation. So, almost as soon as the ink was dry on the switch that in time that saved 9, businesses and other opponents of regulation have been working for the day when they could severely restrict regulatory authority. And that started in earnest under President Reagan, but it's accelerated, and now they are at the point where they have largely succeeded in that. They may become more complacent and proponents of necessary regulation more energized in the process.
Wow, this has been really helpful and really illuminating to me. And I just want to thank you, Professor Levy. That was great.
Okay, well, are we done with the actual podcast at this point?
Oh, I haven't signed us off yet, but is there
Okay.
anything, is there anything like on the, I guess I would finalize my question with, is there anything like on the horizon that, I mean, the term for the Supreme Court is done, but they will come back in the fall. Is that right? They will have cases
Yes.
in the fall. And-
I think the biggest case on the docket so far in the fall is a case that is raising what's called the independent state legislature theory.
Yeah.
And then that could have some pretty profound implications. So for those that aren't familiar with it, the Constitution in Article 1 gives state legislatures the authority to make rules for not only state elections, or actually doesn't confer that, but they would have authority to make rules for federal elections, including things like districting for Congress, and also things like mail ballots and when voting is permitted. Those kinds of rules are actually adopted by state legislatures. Although Congress can override those rules and make its own, if it doesn't, state legislatures set those rules. Now, because the language of the Constitution refers specifically to state legislatures, some people have argued that means only state legislatures can make those decisions, which would then mean neither election officials nor state courts could look at or revise or alter those rules in any way. So in particular, they might prevent a state court from deciding that rules violate the state constitution, and or even the federal constitution, because only the state legislature can decide them. That's a very extreme position, and it would potentially authorize, for example, a state legislature to come in and say, we don't like the results of the popular election for president, so we're going to throw out the vote and make our own appointment of electors, as an example. And nobody can look over our shoulder in doing that because of the independent state legislature theory. Now, in the past, there have been no takers for that theory on the Supreme Court. But the fact that the court has granted review in a case presenting that theory, and at least some of the justices, conservative justices, have signaled some sympathy for it, it's possible that they could decide that that's the correct reading of the constitutional text, which would cause a lot of havoc in state elections, or elections generally.
Wow. Well, everyone, sleep well knowing that.
Yeah, it does cause one to toss and turn, particularly juxtaposed against the hearings on the January 6th committee.
It's a very precarious time in history.
I think that's right, and it is time. If people have been sort of what's the right word? Too busy to be paying attention,
right,
to what's going on, as a lot of people are. We've all got stuff going on in our lives, and paying attention to this stuff is hard. It's hard to generate the energy and enthusiasm. It's hard to believe that your involvement would make a difference. But if people are, sitting these kinds of issues out because they feel impotent or like it doesn't affect them, it's time to start paying attention and get involved.
Couldn't have said it better myself. Thanks again,
Amen.
Professor Levy. And thank you all for listening. We hope you liked this podcast. If you did, subscribe to it on all major platforms, leave a review, share it on your social media platform. I do believe this is a podcast that will generate a lot of interest beyond the 15 or 20 people who may listen to this, none of which include any of my relatives. On behalf of Renew Missouri and on behalf of all of us on here, thank you again for listening. And until next time, take care of yourselves and each other.